Hi, this is Josh Blackman. I'm the president of the Harlan Institute, and it's my honor to welcome you to the 2024 Harlan Institute Virtual Supreme Court competition. This year, mooting the case of Moody versus Net Choice. We have here two of the round of eight teams. From Greenwich, Connecticut, we have John Howes and Shafi Riley. And from the Baldwin School, Pennsylvania, we have Emmy Maida and Lighthouse Wu. And this is the round of eight. Counts will begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Shafi Riley, and along with my co-counsel, John Howes, I represent Petitioner Moody in today's case. Florida's SB 7072 requires social media platforms be transparent and consistent in their moderation decisions and prevents them from using their power of censorship to curtail some of the most important parties in our democracy, journalistic enterprises and political candidates. While they did this to protect the basic functioning of democracy, the 11th Circuit disapproved of it, citing certain impermissible compelled disclosure and the removal of free speech rights of the companies. We ask this court to reverse the decision for the following reasons.
Firstly, the bill prevents and compels non-expressive conduct, which means it does not implicate the First Amendment. The 11th Circuit held that in order for conduct to be expressive, a reasonable person must interpret it as conveying some form of message. By this definition, the editorial discretion that has been protected in cases such as Tornillo is not similar to the content moderation of social media companies. As just like in FAIR, there are many reasons the company may decide to censor a post. So, without additional explanation, the specific reason cannot be inferred, and First Amendment protection cannot be claimed. Furthermore, Florida's bill, compels disclosure of purely factual information, which means it complies with the Zaudera standard.
Second, even if the content moderation decisions of social media companies were to be labeled as expressive, the bill would meet the court's standards, as it not only meets the intermediate scrutiny required of it of such commercial speech legislation by the Central Hudson test, but in fact meets any level of scrutiny placed on it. The bill is in substantial and indeed compelling interest of Florida because, as recognized in Packingham and Biden, social media is the most important medium for free speech, acting as the modern-day public forum. The court has also recognized in Turner and Brnovich that protecting journalistic enterprises
Okay,
and
counsel,
political figures.
if I could interrupt for a moment. Um, so there's been a lot of discussion in this sort of briefing over what exactly is being regulated here. So under the Florida law, what kind of internet sites can be regulated? Help me with that question, please.
Well, Your Honor, the sites that can be regulated are those sites which disseminate user-generated content and pass a certain threshold. I believe it's $100 million annual revenue.
All right, so, you know, we know Facebook would be covered, right? We know Twitter X would be covered. What about like an email platform like Google, Gmail or Hotmail? Would that be covered?
It does not seem under our interpretation of the law that it would be covered by the law. The law clearly applies to social media platforms that use sort of moderation boards, that use direct inference by the companies into the viewpoints that are expressed as a means of benefiting their stock portfolio. Gmail and other sites such as Hotmail or Yahoo are not known to engage in the same sort of conduct as that is being regulated by the Act. They consist of interpersonal communication.
What if Gmail starts deleting people's emails because they don't like their opinions?
Well, Your Honor, that would probably go against this law.
Do you want to revisit your statement? Would Gmail be covered by the statement? I think you just said it wasn't.
Well, if Gmail were to do such a thing, then it seems as though that they would be covered. There is not an established record of Gmail doing such.
Was this
but
issue developed in the trial court?
Sorry, could you say that again?
Was the issue developed in the trial court at whether an email platform might be covered by the statute?
It was not, we don't believe.
Okay. Let me ask you a different question. Did the plaintiffs here bring a facial or an as-applied challenge?
If I'm not mistaken, the plaintiffs here did bring what would appear to be some sort of a facial challenge, which would mean obviously that there would be no potential for the act to be constitutional under any circumstances.
Right. Can you just give me what is the standard we use for facial challenges in First Amendment cases? What is that standard?
Well, the standard is I unfortunately am bereft of the knowledge of the specific case where they reference it, but the standard typically used in the cases is a facial challenge to the statute is unsuccessful unless the court is to determine that there is no possible circumstance in which the statute at issue could be constitutional. We intend to prove that there are many circumstances, including the ones primarily favored by respondents, in which the application of the act would be
So
constitutional.
what are, good, so let's do that. What are some of the circumstances where the statute would be constitutional? Putting aside Facebook and Twitter, what are some of the other circumstances where this would be constitutional?
Perhaps the regulation, if the court were to hold that it could apply to other social media sites, for example, something like Uber or Etsy or something along those lines that clearly do not
Why
engage
would
in
the
this.
statute apply to Uber? Maybe just walk me through that, please.
We believe that we don't believe that it would. However, the court could perhaps reasonably interpret it as covering that. It does regulate online companies such as Facebook and Instagram, and whilst Uber does not obviously engage in the same type of conduct, they do fall in the same sort of general umbrella of using the internet for their operations. They also do involve communications between large corporations and the general populace. They offer an undifferentiated public service. They act as common carriers in much the same way that social media companies do. And
So let me just ask this question. Let's say that we agree that this law can be applied to things like Uber and Etsy and PayPal and Gmail. But let's say we don't agree with you on Twitter and Facebook, right? What do we do then with the as applied challenge? If we agree that it's valid in some circumstances but not valid in others?
well, I was under the impression that the respondents were arguing for a facial challenge. Now,
Okay, so what do we do in this case then?
with this particular case, if they are arguing for a facial challenge, if the court is to find that the regulation is valid as applied to Etsy or Uber or other companies of the same sort, and not valid as to Facebook or Instagram or Twitter or YouTube, then the court would simply reverse the lower court's decision, since unlike the lower court, it would find that there is
Okay,
an
yeah,
instance.
let's say we do that. When you say reverse low court decision, would we leave the preliminary injunction in place while this more litigation is going on?
I think the court in that circumstance would probably be wise to leave the preliminary injunction in case, due to the fact that
You represent Florida. You want the injunction to remain in place?
we do not believe that we do not want it in case, but we do think that the court could perhaps make an argument to that effect. We do not want
Why would we do that? That seems like something your friend on the other side might want to say. Why do we do that?
It very well might. We obviously do not want, I want to clarify, we do not want the preliminary injunction to be in place for the simple reason that it would be
In other words,
enjoining an act.
if we find that the plaintiffs have failed in their facial challenge, what happens in this case?
In this case, then the act is upheld as constitutional, and the plaintiffs will have to simply try again another time.
Okay, very good. All right, you may proceed. About 2 minutes left.
All right. Goodbye.
Okay. So, as recognized in Packingham and Biden, social media is the most important medium for free speech, acting as the modern day public forum. The court has also recognized that journalistic enterprises and political figures are being protected is a substantial state interest. Furthermore, the bill does not target any specific viewpoints as the respondents would have it. Rather, they protect them all equally, and it does not pose any significant
Counsel, I have a
harms to
question
the
for
company.
you. So Facebook would argue that, in fact, you are targeting a viewpoint by, they want to take down vaccine misinformation. And so when you remove a post about, or when you say they cannot remove that post, then you are directly targeting their viewpoint. What do you say to that?
Well, Your Honor, these companies, they say that they curate their communities. Yes, as you're talking about the vaccines, they do say that they curate their communities, but this simply cannot be the case to the extent that the court has protected in the past. And that's why it just doesn't make sense to strike down the bill simply on the fact that they say they can curate their communities. Also, I think the important distinction here is that while maybe they are doing some curating, the interest is so compelling that it overrules any private speech that the companies may say they have.
We'll finish. Finally, as was suggested by Justice Thomas in the case of Biden, social media companies can be treated as common carriers and so can be subject to constitutional government regulation. They've clearly risen from being of private concern to public, as described in German Alliance, and much like traditional carriers, such as telegraphs and telephone companies, they're at bottom communication
Your Honor,
networks.
Your Honor, may we conclude, please?
You finish your sentence, that's it.
Thank you.
SB 7072 does not implicate the First Amendment and passes all levels of scrutiny, so we pray that this court will rule in
Not one
favor of the
sentence.
petitioners.
I heard a period there. All right, thank you, Counselor.
Thank you.
Thank you, Your Honor.
Okay, oops, wrong one. I'll do that. Okay, Counselor respondents, you have 15 minutes whenever you're ready.
Thank you. Mr. Chief Justice, and may it please the court, the Florida and Texas laws facially violate the First Amendment. They defy state action doctrine, undermine the company's editorial discretion, and compel speech. The First Amendment is premised on mistrust of the government and should only apply to state action. Under the guise of promoting free speech, Florida and Texas violate this principle of the First Amendment and extends government power to a point never before accepted by this court. Social media companies also have protected editorial rights. They curate content for their users to pursue a message, similar to parades and newspapers. This model is absolutely essential to their generation of revenue and their expression, and restricting it would impose an undue burden like in Zotterer. Hurley and Tornillo also affirm a private entity's right to exclude in order to protect the free marketplace of ideas.
Florida's law fails under strict scrutiny as it discriminates based on content, speaker, and viewpoint. The manufactured governmental interest of promoting free speech is too vague and are not compelling enough to pass strict scrutiny. Florida and Texas laws also unconstitutionally compel speech. In defiance of PG&E, Tornillo, and Zotterer, they force private companies to disclose information for no compelling interest. Social media platforms are not common carriers nor public forums, and they should not be converted into either. Unlike trains and shopping malls, social media platforms exercise editorial discretion. Today, we pray for the court's relief and we welcome any questions.
All right, Counsel, let me start off with the very first sentence you said. You said that it's facially unconstitutional. So you acknowledge you brought a facial challenge. Can you tell me, in your view, what's the standard to decide a facial challenge under the First Amendment?
Yes, Your Honor. We do bring a facial challenge, and that's for a few reasons because of how egregious this law is. First of all, it targets expressive activity.
We'll get to the minute, but what's the standard under the court's case law to an facial challenge in the First Amendment context? What's the precedent there?
Usually, facially unconstitutional laws are laws that cannot in any way be justified by the First Amendment.
Okay.
Yes.
So yeah, I think the phrase is there's no plain sweep, right? There's no legitimate sweep for this sort of law. So let me ask you about what came up a minute ago, which is Uber, right? Or Etsy or PayPal or Gmail, right? What if Gmail said we're going to start deleting emails of people that we disagree with? We're going to delete all emails from public. We're just going to take down your emails and you'll not get them back.
Your Honor, we believe that Gmail as a private company do have the right to, in this scenario, hypothetically, to regulate the communications between people. However, we certainly concede that the court or the government would find that action problematic. However,
you're darn right we find it problematic. I'm glad you can see that point. But why couldn't Florida apply its law to Gmail? And again, I'm not sure my friend on the other side, their position exactly, but let's say the statute does apply to Gmail. What's your First Amendment argument that you can delete people's emails? Is that editorial judgment, like a newspaper?
Oh, Your Honor, in the end, we would say that that is editorial judgment that has been repeatedly protected by this court. However, we do offer other avenues other than this law. For example, Congress could decide that Gmail should be considered a common carrier, and that would protect it. But the most problematic part.
Sorry, Counselor. But I'm glad you said that. Is it only Congress that can decide what is a common carrier, or do the states have some latitude to decide what is a common carrier?
Your Honor, we believe that Congress should be the only institution that has the legislative power to decide whether a company should be considered a common carrier, because that has always been the case.
However,
Why can't states regulate, the states regulate railroads, states have regulated common carriers. States regulate power companies, they regulate water companies. Why is it that only Congress can decide what is a common carrier? I'm not sure what the authority is for that.
yes, Your Honor, we do agree that in some cases the court could possibly intervene, but at the end of the day, it should be left up to Congress. When we remember the Cable Televisions Act in Turner Broadcasting, we know that Congress brought it up. And through when Congress is the one that is deciding common carriers, it restricts state pandemonium.
I want to get back. I think you're making fair points, but I want to talk more about this facial challenge stuff. Let's say that we think that, sending email is not really editorial judgment, right? When you have a private communication between A and B, if I send you an email that's only meant for the two of us, that's not really editorial judgment. That's like putting a letter in a mailbox and the post office deciding, wow, this is a really nasty message. I'm gonna throw this one in the garbage, right? I think we agree, UPS, if I send you a package with a message in it that vote for candidate X, and UPS says, no, we're gonna throw this in the garbage. I think we all agree that that would not be protected activity because they're delivering like a common carrier. So again, let's say that we agree that this statute cannot be applied to Gmail. I'm sorry, that the statute can be applied to Gmail. Okay, wouldn't that mean your facial challenge fails? That is, if the statute is constitutional in some regards, then it's then your facial challenge fails. Can you respond to that?
Yes, Your Honor. You can always put in some provision to a statute that seemed innocent, innocuous, and then you would say, well, that would still be detrimental for future First Amendment cases. So I think the court should consider the impact of ruling when it tries to
No,
give.
but I mean, my question is sort of more fundamental. If you you did not bring an as-applied challenge, right? You could have, right? You could have said, I bring an as-applied challenge with regard to Facebook and Twitter and Instagram and so on. But you brought a facial challenge. Maybe you're right on an as-applied challenge, but doesn't that not help you here? You hear in a facial challenge. When we just reverse the lower court, let the law go into effect, and then when someone brings a claim against Facebook, you can bring an as-applied challenge. Wouldn't that be the way to litigate this?
Your Honor, we still think that this statute has no constitutional application
What
because
about Gmail? But Gmail, I think we. But you're gonna fight me on Gmail. You're not gonna agree on Gmail. Is that right?
we think that this law could possibly apply to Gmail, which is one of the reasons why it's not narrowly tailored and is extremely problematic.
Okay. All right. So okay. So I think I got your position. So let's say we don't agree with you, right? And let's say that this is the same question I asked petitioners. Let's say that we agree that your facial challenge fails. Is there any way that we can leave the preliminary injunction in place while the case is sent back to the lower court?
Could you, excuse me,
Sure.
could you repeat that
Again,
question?
sorry, it wasn't a clear question. I apologize. Let's say that we disagree with you, right? And let's say that the statute is valid as applied to Gmail. Therefore, your facial challenge fails. What remedy then do you want us to issue if that's the ruling we reach?
Your Honor, if that unfortunately does happen, then we would encourage the court to, well, first of all, reconsider its decision, but also perhaps Congress could pass laws restricting this Florida laws, and we can leave this issue up to Congress. And we also ask that.
But in the interim, what is it that you want us to do, though? I mean, there's a preliminary injunction in place now.
Yes.
If we disagree on your facial challenge, is there any way to leave the preliminary injunction in place while the rest of the case is litigated?
Your Honor, we believe there's still parts of this Florida and Texas law that's still very problematic and needs to be addressed in court. And for that reason, they should hold the preliminary injunction, like the parts when, for example, the laws discriminate, as we mentioned, based on who the speaker, who those platforms are. Like our friends on the other side mentioned that there's a 100 million monthly user threshold. And we think that arbitrary number is really unconstitutional in the sense that it targets certain speakers. So for that reason, we must still, the court still needs to review this law for its very unconstitutional parts.
We could bring this up, yeah,
Go
up
ahead.
again.
Go ahead.
And we could also have the court, if it does wrongly decide that it's not facially unconstitutional, they can bring it up
You keep
later.
saying wrongly. I mean, if we disagree with it, doesn't make us wrong. I think it makes you wrong.
That is a fair point, Your Honor. That is a fair point. But possibly then we could bring it up as an as-applied challenge, because in that case, it would still be ruled unconstitutional.
Very good. All right. So let's sort of turn to the merits now. I want to talk about Section 230 for a bit. How does Section 230 interact with your position, please?
Your Honor, Section 230 give, as we interpret it, gave social media a lot of power to regulate what their user post on their platforms, because Section 230's primary goal was to remove defamation liabilities from those platforms so that social media have more freedom, more rights to regulate what people post on them. And we can consider this Section 230 as a protection for the private companies.
Okay. So let me ask you a question, right? If we rule in Florida's favor, right, and we say that this statute is valid, might that create conflicts with Section 230?
Your Honor, it still wouldn't create conflict with Section 230, because we can consider Section 230 and First Amendment status to not go hand in hand, and they can each stand alone. For example, we see that newsstands aren't held responsible for the materials that it distributes, but it does have the right to choose which newspapers to distribute and display. We can apply the same thing to social media. They shouldn't be held responsible, but they can still choose which newspapers to distribute.
All right. Let's sort of pivot and let's look at the merits. Can you address Hurley, Tornillo, and PG&E and how they might affect your case, please?
Sure, Your Honor. In Hurley, this court recognized that private speakers had the right to exclude unwanted message from their parade of ideas, we would say. And in Tornillo, this court recognized that a private speaker reaffirmed that a private speaker has the right to exclude. So we think Tornillo and Hurley are very helpful cases for our position, in the sense that they provide a structure for how the court should decide on social media cases, because social media very similarly exercise editorial judgment and should be compared to standards like that in Hurley, Tornillo.
Exactly. And just like
Well,
Hurley.
if I may, I'm a little bit confused, because I don't really see the social media companies sort of delivering us a message when they remove content. You know, in Hurley, they wanted to stick to the main message of the parade. They didn't want to diverge from that. In Tornillo, they wanted to say, we don't like this politician, or we choose not to endorse this politician. What's the message being expressed here by the social media companies?
Your Honor, we believe that social media companies, by removing certain political candidates or by banning certain kind of content off their platform, often political, they are expressing their own message by saying, we don't host that kind of speech on their platform. We just choose certain speakers because that's what we as social media platforms.
Is there really any way to know that? How do we differentiate between someone who deletes a post, someone who deletes their account, or someone who is deleted by the social media company?
Your Honor, when social media platforms host users, that in some ways means social media condones this user. This is dangerous for their message. This may be dangerous for their message. And in that case, they have full rights to take it down. For example, we know in Hurley that it didn't align with their message. And in that way, we can consider social media to be like a digital parade of ideas.
All right, Counselor, maybe one last question to ask. Facebook and Twitter operate in other countries, right? And other countries don't have a First Amendment. Don't other countries require Facebook to take stuff down? And if they can operate there, why can't they operate here under the same rules?
Your Honor, those are vastly different legal systems that we
I
have
get
to.
that, I get that, but they operate. Facebook exists.
Your Honor, could you rephrase that question, please?
How does Facebook exist in countries where they're required to take stuff down by the government? They exist. You know, I mean, they don't like it, but they exist.
Then in most cases, those companies abide by those laws.
Okay, all right, thank you, Counselor. Time's up.
Thank you.
All right, 5 minutes for the petitioner, please. Whenever you're ready.
May it please the court. Respondents err in their analysis of today's case for the following reasons.
They refer to Florida's bill as creating a press controlled by government. This is both an unfair assessment of the content of the bill and a severe misunderstanding of the nature of social media platforms. One, they are not press in the sense that the court has ever projected. Traditional press has one specific purpose: to inform the populace about the ongoings of the world. Social media companies, on the other hand, have no one particular purpose. They rather distribute outsourced speech by private speakers. For this reason, their editorial.
Counselor, but can't Facebook define for itself what their mission is? Why do I need to listen to your, you might disagree with them, but can't they decide what their standards are? Don't they have these approvals?
They most certainly can. However, the court ultimately is the true total arbiter of whether or not that standard
Why
is.
can't we defer to how Facebook envisions itself?
Could you repeat that, please?
Why can't we defer to how social media companies envision themselves? If they tell us we are here to exercise judgment, why can't we agree with them? Why is that wrong?
Well, Your Honor, it seems like they are speaking out of two sides of their mouths sometimes. For example, they signed the Santa Clara Principles, and they endorsed basically very
That was
similar.
voluntary, though. But that was a voluntary. It wasn't compelled by monetary penalties from the government.
Well, that's why I'm saying they're speaking out of two sides of their own mouths. They
I
voluntarily.
think so. They're saying on the one hand, we can regulate ourselves, but we don't want to have the threat of civil enforcement against us. Why is that hypocritical? I think that's a reasonable position any business would take.
Well, the Santa Clara Principles basically advocate for transparency and in the in their editorial discretion, or what they call editorial discretion. And respondents are basically arguing that they don't need that transparency because they're private companies.
In addition, the court has, in previous cases, such as Roberts versus JC's, held that even if a private business is to define its own mission by itself, it can still be regulated by government if that regulation serves a compelling governmental interest and is narrowly tailored to effectuate that interest.
Furthermore, we wouldn't say that the bill is necessarily preventing them from carrying out their terms of service. The bill simply advocates for transparency and makes sure that they're able to carry out their terms of service better in some ways, and that they're
Aren't they in the best position to decide what's better for them? I mean, it's nice for you to say that, but that's their position, isn't it?
That may be a reasonable position to take from an economic or a philosophical perspective, but from a legal perspective, the court is the ultimate arbiter on cases that go before it. And if the court is to determine, as we should hope that it would, that the stated purpose of the companies before us is inconsistent with their practices, and their pleading is held to be rather irrelevant in the case before us.
Right, and as the court recognized in Packingham, these social media companies are so important in the public sphere as a public forum for speech to be heard, and so that kind of goes into common carriage. We believe that social media companies, for the reason that they're so important for free speech, are common carriers.
All right. Let me sort of change directions. Let's talk about Tornillo PG&E a little bit more. You keep saying there's no editorial judgment, but was there anything in Tornillo that says editorial judgment, has to come at the front end? Why can't it come at the back end?
Well, the general gist of the opinion in Tornillo is to the effect that editorial judgment is practically reserved to those companies, those news organizations that actively promote promote a sort of viewpoint, or if not promote a viewpoint, at
But there's a
least
viewpoint, and
act.
you keep denying it, but Facebook and Twitter say they have a viewpoint and articulating through their community standards.
Well, I would say the biggest distinction here is that the editorial discretion of these newspapers is a very deliberate and intensive process, whereas the editorial discretion of the social media companies is really at some points it becomes a free for all. There are, I know, many millions of posts which go against the community standards and which
Yeah, but
haven't gone through.
but I mean, they don't have to enforce 100%, do they? For it to be a standard?
I'm so sorry, I could not hear what you
Sure,
just
sure.
said.
I'll give you a chance to finish. You know what? Time's up. It's fine. I'll
Yeah,
withdraw.
all right. All right. Thank you, Mr. Chief Justice, and we hope you will resolve the decision in our favor.
Okay. All right. Very good. Thank you. Thank you both very much. You can tell that was a little bit hotter than last time, wasn't it? And I was a little bit more aggressive.
Significantly.
Well, no, it's deliberate. It's not because I'm a mean person, but maybe I am. But I was trying very hard because um, I know that you understand the case. So my goal today was to put you outside your comfort zone and to push you very hard to things that aren't obvious. So as you can probably tell, I spent a lot of time reviewing the oral arguments in this case. And there was a lot of discussion on the facial versus as applied challenge. Just for the future, just when I say what's the standard or the precedent, I'm asking for a case. I'm not asking for particulars of this, net choice Facebook. I'm asking about what case or precedent discusses the facial challenge. And one case when I think about is Americans for Prosperity versus Bonta. One case to think about is Americans for Prosperity versus Bonta. I'm actually teaching in class this evening, so it's on my mind. But it has to do with the California law that requires disclosure of lists of donors who donate to a charity. And one of the questions is, do you strike the law down with regard to just the two plaintiffs who brought the case, or do you kill the law altogether? That's the overbreath question. And Justice Thomas doesn't believe in the overbreath doctrine. He says you can only, invalidate a law with regard to the people who actually are injured by it. And he might be right about that. So something to think about carefully is how you do this. I was curious though that Emmy Lighthouse said no, Gmail, they can delete the emails. That's not a crazy position. In fact, I think I like your answer better than the one that was actually given at the Supreme Court, because once you concede, and maybe you thought about this, I don't know, that no, you can't delete emails. Well, then what's the difference between an email and a tweet, right? Maybe you thought about this more than I have, but
I remember
sometimes when you're a lawyer, I'm sorry, Linus, what did you say?
I remember there was a case when the court allowed a private company to put like newsletters into their mail.
I think that was PG&E.
Mhm.
Yeah.
Good, yeah. Yeah.
So in that case, I suppose it could be similar to email. I don't know about that. though.
Gmail.
Well, let me make a different point to sort of commend the argument. Sometimes as a lawyer, you have to draw a line, and you can't cross that line, because once you cross the line, you give your case away. And I think once you argue on your side that, oh, they can't delete Gmail, then your facial challenge fails, right? Once you accept that there might be circumstances where the statute's valid, your facial challenge fails. And that gets to the point your friend the other side had a couple questions on is, what do you do if the facial challenge fails? Do you simply dismiss the case outright? Do you send it back to the lower court to figure out the as applied? What happens to the preliminary injunction, right? Net choice, you want that injunction to remain in place. Florida, you want to get rid of that injunction, right? So how do you deal with the remedial issue of what happens to the injunction if the lower court rulings vacate? It's actually a very hard question. I don't know what the court's going to actually do with it. It's actually really tough. But the applicability of this law to things like Uber and PayPal and Cash App and Venmo and Gmail is actually much trickier than the application to Twitter and Instagram. Just a little bit more feedback. I couldn't tell if you were reading from the screen. Maybe you were, maybe you weren't. Don't ever read. At this level of the competition, it's got to be up here. Because like with Zoom, I can't quite tell if you're looking at the camera, looking at your screen, because the eyes are beating. So I can't tell. But if you were, don't read anymore from the screen. Your both of your cadences are good. Your pacing is good. I think you had pretty good handoff between one and the other. It wasn't quite 50-50, but it was maybe 60-40. So you have to just work on sort of getting it more smooth. I think the better way of doing it, since you're both in the same location, is just even just like a nudge, or you could have different ways of doing this. It's harder to do this in person, but I won't really tell if you kind of like lean and see who's gonna argue it. You handle the interruptions well. It's a very hard skill though. When a question's asked, you stop talking immediately. It's hard. A couple of times you didn't quite do it, but you got to work on that, and you do well in the aggregate. Some of my questions were very long, mostly deliberately and winding, and you lost track of the thread. You can say, Your Honor, I don't understand the question. You're allowed to say that. It's better for you to ask to repeat the question than to answer the question with a poor understanding. So if I ask you a really long question and you don't really understand, you say, yes, Your Honor. Whoa, right? You said yes to something you don't know what you said yes to. So it's actually better to sort of say, I didn't get the question. And I think most judges will say, okay, maybe that wasn't framed coherently. They'll re-ask it. The clock is the clock. When the clock turns red, you stop. Just give one sentence. I remember when I was doing moot court in high school, I would run on with semicolons and periods. We don't do that. So you stop when you stop. Okay, those are my comments. Alex, anything that you want to add?
I think Professor Blackman covered most of what I was thinking. I thought this was a very solid round. I thought the command of case knowledge. I mean, obviously, at this point, everyone's going to know the cases, but I thought Bill did a great job of not just like recapping the cases for us. You did a good job of extracting the legal principle that you wanted us to take from it, and I think that shows some skill. So I was impressed with that. I do agree. Just try to work on the handoffs slightly better. I mean, it was pretty close, but just when you have it 50-50 when you have a partner is just it really does make you both look stand out. And so I think that's all I have though.
Okay. What questions you have for us?
We are generally satisfied with the level of commentary you've given us, right? I don't think we really have any huge sources of inquiry.
Ben, quick question. If I was wondering how you would kind of interpret this law to apply to Uber, because I hear some people saying it would it would allow them to like discriminate who they allow to use their services, but then also it's like that the law just applies to Uber's direct messaging.
Imagine a shadow ban of Uber, right? In other words,
right.
you have an account on Uber, but every request you submit is denied for a car, right?
So that technically could allow Uber to discriminate on the basis of like race, which I see.
Well, it's even beyond race. I think the argument would go something like this. The statute applies broadly to internet services. That's why I think the first question I asked the petitioner. It applies very broadly. Does it apply to Uber and vehicle and PayPal? Imagine PayPal says, we're going to just quietly block financial transactions of Republicans or Democrats because they're not consistent with our community standards. Race is easier because there's statutes barring racial discrimination, but there's generally not discrimination on the basis of political ideology. So imagine PayPal says, we're just deleting financial transactions from Republicans. We don't like them. Or Gmail says, we're going to delete all Democratic emails. We don't like them anymore. At some point, PayPal looks a lot like a bank, right, which is a common carrier. And Gmail looks a lot like FedEx or UPS or a telegraph company, which is, a communications mechanism. Uber looks like a taxi company. I mean, it's not exactly the same, but it's kind of like a taxi company. Imagine, you hail a taxi, and because you're wearing a red, Make America Great hat shirt, they don't pick you up on the curb, right? So the Uber argument, I think, is actually very powerful. I don't think this was developed in the lower court at all. So this does come up at the Supreme Court, but I think it's actually very hard.
Yeah, it is really.
But again, I think you held your line, and maybe you had to. If I would have pushed you again, I would have asked you about common carriers. Like, at some point, isn't an Uber like a taxi, like a common carrier? Could a cab company say we will not give rides to Democrats?
Yeah, that is a really difficult line. I don't know.
It's good. I'm glad you're thinking about it.
All right.
All right,
Thank
what other
you.
questions you have for us?
No, I don't believe there's anything else really.
Okay, good. Well, we have one more round after you today, about 10 minutes or so. We have another round tomorrow. Hopefully by Wednesday or Thursday, have all the results posted. And we will find out who is in the next round, next 2 days or so. Well, I want to say congratulations. You've all done very well. This was very hard, not easy, and you're arguing at a level far beyond your ages. So I always take my hats off to you.
All right. Thank you so much.
Thank you.
Thank you.
Thank you so much. Take care, everybody.
Thank you.